Hello, my name is Anthony Randazzo, and I am a partner at Seacrest Wardle, which is headquartered in Troy, Michigan. Today I'll be presenting a webinar to you concerning damage claims arising out of a flood. The title of the webinar is Don't Get Washed Away with Flood Claims. Now, if any of you were fortunate enough to be present in the metropolitan Detroit area, let's say on around August 11, 2014, then you would have likely witnessed one of the most historic rain events in Michigan in, let's say, the last 150 years. According to observation towers at Detroit Metro Airport, there was approximately 4.57 inches of rain recorded. Now, that is, quite frankly, a whole lot of rain. The only rain event that actually had a higher rain total for a single event occurred back on July 25th of 1925, where there was a recorded 4.74 inches that fell over the Detroit metropolitan area. A rain event like the one that was seen on August 11th is a very significant rain event. A rain event like that has a likelihood of causing severe flooding, which will in turn lead to property damage. Now, the property damage becomes a real problem when floodwaters rise to the level to enter a residential home. Obviously, when that occurs, residential homeowners get very stressed out, get very mad, and they naturally want someone to pay for the damages that they sustained. Whether it's personal property or real property, they look to someone to pay them compensation for those damages. Since most of the flood events happen to involve a sewer disposal system, the sewers and tunnels that run through cities and townships, most of the residents who experience flood damage to their home look to municipal defendants to pay them compensation. The claim is that something went wrong in that system which caused flooding in their home. While we'll get to those types of claims in a minute, I want to just briefly describe the three basic types of claims that people have who have experienced flood damage. The first claim is a claim that an individual will look to their own insurance carrier to pay them compensation based on their insurance policy. That's what's known as a first-party claim. The second claim is claims that are being brought against, as I stated earlier, municipal defendants, a governmental entity, and the insurers who insure those entities. In those entities are looked to be held liable by a residential homeowner. This is considered your third-party claim. The third type of claim that really arises out of these flood damage incidents is claims by an insurer against a municipal defendant. And this would be based on a subrogation theory of liability. This is where the insurance company pays out their insured on that first-party claim, then retains subrogation rights to look to someone else who is to be held responsible so that they can recover the amounts paid to the insured. In this webinar, we will focus on those claims that are being brought by an individual seeking compensation against a municipal defendant and the municipal defendant's insurer for flood damage. However, that's not to say we're not going to touch upon, at least briefly, on some of the other claims identified. In particular, we will look at the claims that are being brought by an insurer against municipalities on a subrogation theory of liability. There are a couple of instances in this webinar that an insurer is going to pay particular attention to when considering whether or not to file a subrogation claim against the municipal defendant. So right now, for my insurance friends in the audience, I'd like them to write down two words, which we'll get to later. The first word is notice, and the second word is document. And toward the middle of this webinar, you'll understand why these words are important for the insurers who may think about filing subrogation claims relating to flood damage. we will not be covering the first-party type claims between an insurer and their insured over flood damage. While there may be some helpful background information on flood type cases that you'll learn in this seminar, those claims are really fact-specific depending on the type of policy an insurer had issued to its insured. So those claims will not be discussed during this webinar. Again, that's not to say that the information contained in this webinar is not going to be useful to an insurer. As previously stated, we are focusing the discussion here on injured parties pursuing litigation against a municipality for an injury to person or property resulting from a flood. Now, the first thing that may pop into your mind is, well, you know, hey, I thought there was something called governmental immunity which prevented a municipality from being sued in tort. And to that, I would say you're exactly correct. There is something called governmental immunity which does bar, generally, tort suits brought by an individual who has suffered property damage or injury to one's person in tort. However, there are exceptions to that general rule. So what I want to do now is kind of go over the history of the exception relative to flood-type cases. In 2001, the Michigan legislature enacted Public Act 222 of 2001. And it makes it clear that there are certain instances when our government is going to be held liable for sewer backup claims. In particular, the Act amends Michigan's governmental immunity statute to limit liability of governmental agencies for sewer backup claims and establishes a process for a person seeking compensation for a sewer disposal event. With any other exception to governmental immunity, these exceptions are extremely narrow, and they are to be construed narrowly by a court. A person who seeks to avoid governmental immunity has the burden to prove that an exception applies. That person who seeks to avoid governmental immunity must also plead avoidance of governmental immunity when he or she files his or her complaint. The enactment of Public Act 222 has now abolished all of the common law exceptions to governmental immunity on this issue. As a result, the municipalities are now subject to tort liability for what is termed an overflow or backup of a sewer or sewage disposal system in certain identified circumstances. The statute that gives rise to the sewage disposal event exception is MCL 6911417. The reason why this statute was enacted obviously comes from A, public policy, and B, it is an ability to provide property owners and individuals along with governmental agencies a greater efficiency, a better process to resolve potential disputes over sewage disposal event claims, sewer backup claims, to the extent the statutory exception has been complied with by the claimant. Under subsection 2 of the statute, we see that the legislature maintained the general rule that a governmental entity is immune from tort liability for overflow or backup of sewage disposal system unless certain circumstances exist. And here it's unless the overflow or backup is a sewage disposal system event and the governmental agency is an appropriate governmental agency. We're going to get to defining those terms in just a second, but before we do, I want to just take a minute to note that this exception, this limited exception, where a individual who believes he or she has been injured from a flood may maintain an action under the sewer disposal event exception, and only under this rule are they allowed to recover. As stated in the statute itself, this is the sole remedy for obtaining any form of relief for damages or injuries, regardless of theory of liability, that arise from these types of claims involving a flood. Okay, so now we need to define some terms, because you're probably asking yourself a couple of questions. One, what in the world is a sewage disposal system? And two, what is a sewage disposal system event? So let's go ahead and define those terms right now. A sewage disposal system event means the overflow or backup of sewage disposal system onto real property. And I love it how they use additional phrases that need to be defined when you're defining a word. But they use, again, the backup of a sewage disposal system. So what does that mean? A sewage disposal system under the statute means all interceptors, sewers, storm sewers, sanitary sewers, combined sanitary sewers and storm sewers, sewage treatment plants, and all other plants, works, instrumentalities, properties used or useful in the connection or collection, treatment, and disposal of sewage and industrial wastes, and includes storm water drain systems under the jurisdiction and control of the governmental agency. It basically means any lines that can be any way related to the sewer system that are owned and operated by the government is considered part of that system. So if there is a backup of that system, that governmental system, onto real property of an individual that causes damage, then that individual may have a claim. Now that we know what generally consists of a, or what is considered to be a sewage disposal event, let's look at a couple of categories which the legislature chose to outline as not being considered a sewage disposal event. So if any one of these three things is true, then you don't have a claim. You don't have an event that would constitute a claim under this narrow exception to governmental immunity. And those three things are: one, an obstruction in the service lead that was not caused by a governmental agency. Again, a sewer service lead means that instrumentality, that connection between the home and the governmental sewage system. And we'll show you what I mean when I say this in the next slide, which contains a figure. But before I get there, I want to talk about some other things that are not considered to be part of a sewer disposal event. So two, the connection to sewage disposal system on affected property, including but not limited to the sump system, building drain, surface drain, gutter, or the downspout. And three, this is an easy one, an act of war. Clearly, if an act of war occurred, we're not going to blame the local government for causing a backup. So that one's pretty easy. So let's look at what I mean when I talk about what is not going to be considered enough or sufficient to constitute a sewer disposal event. Okay, now I'm showing you figure one. It's a house. It's got some drain lines, and I'm going to use my pointer here to kind of run through this for you. Here are some drains in the blue that come around the house and come out, and this will drain into the storm sewer here. Next to it, in this white pipe here, this is a sanitary sewer lateral. This service line here on this part, which is above this red line, this is the property line. Anything above the property line and toward the house, which is owned by the homeowner, is the responsibility of the homeowner. So if there's a crack, if there's an obstruction not caused by the government, that's the responsibility of the homeowner, and you cannot claim that under this narrow exception to governmental immunity. This would not be a sewage disposal event. However, when we cross this line, we get into the governmental territory. So the lines on the side of the line that is owned by the government if the obstruction occurs there, if the defect occurs there, if something occurs on this side of the line, then that is considered a sewage disposal event that may be actionable depending on some other factors, which we'll get to in just a second. You know, before we press on here, I'm going to go back one slide because I think we need to define something real quick, and I think it's an important item to be defined. Earlier, again, we talked about certain circumstances that are not going to be considered a sewage disposal event. And let me just read, because this is the language from the statute, and it states, an overflow or backup is not a sewage disposal event if any of the following was a substantial proximate cause of the overflow or backup. The term substantial proximate cause, as used in this statutory scheme, means that 50% or more of the cause. So, if you have any one of these three items being 50% or more of the cause of the damage, then you do not have a sewage disposal event. You do not have a claim that could be pursued in court because you will be barred by governmental immunity. You don't have a claim. Now I'm going to fast forward a couple of slides. All right, now we've looked at what is generally considered a sewage disposal event. We looked at what is generally not considered a sewage disposal event. And this tells us whether or not a person who has been injured or potentially injured by a flood is on the right path and could potentially make a claim against the municipality. Once we define whether or not this is considered a sewage disposal event, it's not over for the claimant because they have to prove liability. They have to prove that they have a claim that will withstand scrutiny. And this is where we get to the point in time where we show what are the elements that a claimant must prove to actually succeed on a sewer disposal event claim. There are 5 items that a plaintiff must show. They must show each and every one of these items in order to be successful in a sewer backup case like this. The first item is that at the time of the sewage disposal event, as described previously, the defendant governmental agency owned or operated or directly or indirectly discharged into the portion of the sewage disposal system that allegedly caused the damage. So we have to have here the right governmental agency. They have to be the right governmental agency who has control over the instrumentality causing the potential harm. The second thing that an aggrieved party must show is that the sewage disposal system that we discussed earlier has had to have some construction, design, maintenance, operation, or repair defect. So not only do we have to prove that the governmental agency is the right one, but we have to prove that the system over which is they operate or it operates has some defect in it. The next element that an aggrieved party must show is that the governmental agency knew or in the exercise of reasonable diligence should have known about that defect. The fourth element is that the governmental agency, having the legal authority to do so, failed to take reasonable steps to repair, correct the stated defect. And 5, the defect at issue that's being claimed, again, must be the substantial proximate cause of the event, property damage, or physical injury. So the defect has to be 50% or more the cause of the damage. If it falls less than that, there is no claim. The plaintiff cannot recover. In fact, if the plaintiff falls short on any one of those 5 elements, the plaintiff cannot recover. Again, it's a very narrow exception to governmental immunity, this sewage disposal event exception. So there must be some strict compliance with the statute in order to recover. So let's review at this point. Once we understand we are dealing with a sewage disposal event, which is the overflow and backup of sewage disposal system owned and operated under the jurisdiction of the correct governmental entity, the claimant must prove 5 elements to liability, as just discussed. And again, if you can't show any of those or all of them, the plaintiff is going to lose. It's also worth noting here that the 5 elements to a proper claim to prove liability is a very, very, very factually intensive area. Whether or not there's a defect, whether or not the government had knowledge, whether or not their actions or inactions were reasonable or unreasonable, whether or not there were steps taken to correct the problem, and the percentage of fault potentially that could be attributable to a proper governmental entity. That's a lot of factual questions, a lot of potential disputes, which means a lot of experts are going to be battling over those questions. And if there is a question as a battle between the experts on these issues, it's going to be difficult to win a motion for summary disposition. But these are, I'm not saying it's insurmountable to procure the admissions, but this is a very, very fact-specific area of the claim. So at this point in the webinar, we now know that there's an exception to governmental immunity for these cases that involve sewage disposal events. We know that these overflow and backups occur if they occur on property of an injured party, and they occur because of something that was defective in a sewer disposal system operated by the government. Then the claimant, the injured party, may have a potential claim. And I stress the word may because before a party is authorized to file a lawsuit against a governmental agency for a sewer backup, there are certain statutory requirements that that party must follow. If they don't follow those statutory requirements, they will not be able to utilize this exception to governmental immunity. And the statutory requirement that I'm going to talk about now, which is probably one of the biggest offenses that municipalities have to these types of claims, is it's the statutory notice requirement. Specifically, a claimant who believes that his or her damage has sustained damage from a sewage disposal event must first comply with the statutory notice requirements set forth in. This is an important statute to look at, to have at your fingertips if you're a municipality, or even if you're an insurer who is paying out claims and going to file subrogation claims. It's an important statute to have at your fingertips. It's MCL 691.1419. And I'm going to go ahead and just read the relevant provisions from that right now. Except as provided in subsections paren 3 and paren 7 and paren, a claimant is not entitled to compensation, under Section 17. That's the exception. Unless the claimant notifies the governmental agency of the claim of damage or physical injury in writing within 45 days after the date the damage or physical injury was discovered, or in the exercise of reasonable diligence should have been discovered. This statutory notice, this requirement, is not discretionary. It's not voluntary. It's something that is mandatory. If you want to file a claim as a claimant or as an insurer that's going to be filing a subrogation claim, you have to make sure that that notice is properly given. My insurance friends, earlier on I told you to write down a couple of words. The first word was notice, and this is the part that I need you to pay particular attention to, because when you file a subrogation claim, you're standing in the shoes of your insured, Okay, so you only have those rights your insured would have. If the insured does not follow through and provide the requisite statutory notice to the municipality that he or she feels is responsible for the flood or the flood damage, then you may lose your ability to recoup any money you pay to the insured from the potentially responsible municipality. So as a practice pointer, if you're dealing with your insured in investigating a claim, a first-party claim, the first thing you want to make sure you do is to ask them whether or not they properly filed notice of entities, on entities or governmental entities that may be responsible. This will essentially save your position in line in the event you feel that you have a case and that you want to pursue a subrogation action. So this is a very, very, very important provision, and I'll discuss some case law later on that kind of deals with this issue of notice, strict compliance with notice, and the harsh reality that occurs if notice is not complied with. Conversely, for my municipal friends out in webinar land, this is one of the biggest offenses that you have potentially. You know, oftentimes individuals either forget or just don't follow through, or maybe not even know about these requirements, and for whatever reason they don't file the proper notice of claim as required under this statutory exception. And the failure to do so, again, does have harsh consequences. So when you get a case in, the first thing I would be looking at defending these types of cases is, was notice properly and timely submitted to the municipality? Because if it wasn't, then the first thing I would do out of the gates is file a motion to dismiss based on governmental immunity. I've recently done this in 3 or 4 cases successfully to avoid having to go through the entire discovery process and waste time and money when we knew that notice was not properly given. And courts do follow the law in this area because it is very strict. And again, we'll go over this in just a moment. We'll go over some cases that kind of discuss what I'm talking about. Now, throughout this webinar, I used the word subrogation, defined it a little bit, but you know, the insurer potentially does have a right to file these types of claims against municipalities because they are properly defined as a claimant under the statute. And I'll go ahead and read that right now. It comes from MCL 691.1416 and this comes from the definitional section of the statutory scheme, and it defines claimant as follows. It means any property owner that believes that a sewage disposal event caused damage to that owner's property. Physically injured individual who believes that sewage disposal event caused physical injury, or a person making a claim on behalf of a property owner or physically injured individual. And here's the important language that gives the insurers an ability to file subrogation claims. Because the claimant is defined to include a person that is subrogated to a claim of a property owner or physically injured individual described in the subdivision. So this language gives insurers the ability to file subrogation claims against municipalities and stand in the shoes of their insured to recoup some of the monies paid out on a flood claim in a proper case. Now, up until this point, I've discussed the notice requirement, and I discussed the harsh reality that, you know, a claimant who wants to file a sewer backup case must comply strictly with the statutory notice requirements outlined in the sewer disposal event exception to governmental immunity. Now I'd like to kind of discuss the flip side of that, because again, with every exception there is another exception apparently. And here there is an exception to give a claimant some wiggle room to not comply with the statutory notice provisions. It's a narrow exception, and let's go over that right now, because there are certain duties that arise that a municipality must pay attention to if they are provided telephonic or written notice that a aggrieved party may file a claim and is inquiring. So this is a situation where a person believes they have been injured from a sewer disposal event, calls up the city or writes them in an email and says, hey, listen, I got this flood damage potential claim. What do I do from here? At that point in time, once the municipality has notice of this potentially injured individual, the duty shifts to the municipality to do certain things. The duty to assist the potentially injured individual in properly and timely making a claim, filing his or her notice of claim. So I want to go over that right now. So the question posed is, does a municipality have any duty to assist the claimant to provide statutory notice? The answer, of course, is maybe. It depends on whether or not that municipality was contacted and kind of given notice, although not formal notice of claim, given notice of this potentially injured party. In that circumstance, if a person who owns or occupies affected property notifies a contacting agency orally or in writing of an event before providing the notice of claim that complies with subsection 1 that we just went over, the contacting agency shall, just like must, you got to do it, shall provide the person with all of the following information in writing. So there are some very unambiguous terms there. If the city or municipality receives word from an affected individual of a potential claim, the contacting agency, that municipality, must give that person in writing the following information. The first thing they have to give them is a sufficiently detailed explanation of the notice requirements in subsection 1. This is to allow the claimant to properly and timely file that notice of claim. The second item under B is the name and address of the individual within the governmental agency to whom a claimant must send written notice under subsection 1. So we have to give them what the requirements are. We have to give them the proper address of who this claim form should go to. And then finally, C, the required content of the written notice under subsection 1, which is limited to the claimant's name, address, telephone number, the address of the affected property, the date of the discovery of any property damages or physical injuries, and a brief description of the claim. And just to be clear, the term contacting agency in the context of this statute is defined as the clerk of the governmental agency, an individual who may lawfully be served with civil process directed against the governmental agency, or any other individual, agency, authority, department, district, or office authorized by the government agency to receive notice under subsection 19. Now, some of the my municipal friends out there may be asking themselves, well, why do I need to pay particular attention to this this requirement, this duty? The answer is simple. If you don't follow this rule in particular, in provide information, the listed information to a potential claimant, then you will not be able to shield yourself from liability if that claimant does not provide timely notice. It's as simple as that. If you get word that the individual has a potential claim and you don't help them out, you don't give them things that are identified that we just went over, those three things, to allow them to make a proper and timely notice of claim, then you can't use that as a defense, plain and simple. And that's harsh too, because remember, the notice defense is a very, very, very strong defense. It is a defense that you can get rid of a lot of claims very easily, because again, generally speaking, people just don't file these things for whatever reason, and so if you comply, then you're just giving yourself an additional possible defense that's very strong. So I would pay particular attention to this, and I would make sure that as soon as you get those forms in, as soon as you get a writing in, as soon as you get a phone call, that you have some central diary system to make sure that you are mailing these individuals a packet of material that contains the information required so that you can satisfy your duty and maintain that potential objection and defense in the event the person who you sent that material to does not file a timely claim. Now, in researching cases on the sewage disposal event exception, there's not too many cases out there. I mean, the statute's only about 14 or so years old, and there's not a ton of cases out there, primarily because most of the issues that may arise concern factually disputed items that we talked about, those elements of liability that may have not made its way to the appellate court level. But for most of the cases that did make its way to the Court of Appeals, they tend to focus on these notice requirements. And so what I'm going to do right now is kind of go over some of the important cases, I think, the important cases that discuss the strict requirements set forth in MCL 691 period 1419, and kind of describe to you, in as far as case law, what I was discussing a little bit earlier. The first case I want to talk about is Willett versus Waterford Township. And in fact, another case similar case is Jackson County Drain Commissioner versus the Village of Stockbridge. Both of these cases reiterate the general rule that a claimant has the burden to prove that he or she complied, specifically complied, with the 45-day notice requirement to avoid a dismissal of the action based on governmental immunity. If you don't follow that 45-day notice provision, if you don't give proper notice timely, you can't take advantage of that exception to governmental immunity. Your case will be barred based on governmental immunity. And those two cases reiterate that fact. The next case, however, I want to discuss is a little bit different. It's a case entitled Great Northern Insurance Company versus City of Allen Park. It's a 2012 case, and although it's unpublished, it is persuasive on the issue that has been presented, especially considering the fact there's not a whole lot of law in this area. And in that case, the court held that if a claimant gives notice, a proper statutory notice on governmental entity A, the notice is only good as to that specific entity and to no other entity. So let's just go for an example. For example, claimant has a flooded basement, is injured, damages, his personal property is damaged, he wants to sue somebody. And so what he does, or she does, is she files a timely claim form for City A. Believes it's City A that caused the defect, caused the problem, and should be to preserve that person's right to sue. But when they sue, they learn that actually it's governmental entity B, a neighboring community, that actually caused the problem. Well, if the claimant didn't file a notice of claim on that other entity, then the claim is going to be barred, because the notice on the non-culpable entity does not serve notice on every other entity. You have to serve them all individually, all separately. That is a very, very important It's a very, very, very important topic, a very important issue that must be considered by the claimant. And again, I'll just highlight this for the insurers in the audience who may handle subrogation claims, that when you get a type of claim, when you start negotiating or start talking to your insured about paying out in a first-party claim for flood damage, and you want to potentially seek subrogation against a potentially responsible governmental entity, you want to ensure that the insured gives proper notice, not just to one governmental entity, but all possible governmental entities that could be potentially liable. Because this case is out there and it kind of makes it clear that notice on one is not notice on all, you got to ensure that the proper notice is given to each and every potentially liable governmental entity, or risk being barred from pursuing that case. The next case I want to discuss is a case entitled Dabata versus the County of Wayne. This case is a Michigan Court of Appeals decision, 2010, a published decision. It examines the exception to the notice requirement that we went over briefly earlier in this webinar. And it held that a failure of a municipality to provide a claimant with information on how to make a proper claim upon inquiry will excuse that claimant from the strict 45-day notice requirement set forth in MCL 691.1419. So again, my municipal friends in the audience, you got to make sure that if you receive any notice of a potentially injured party that relates to flood damage, you have to ensure that that individual receives the requisite written notification on how and where to make that properly filled out claim. If you don't exercise that duty, if you don't fully discharge that duty as required, then you will lose your ability to defend the case and raise the notice offense to the governmental immunity exception. So you have to make sure that there is some process when you get these claims in, there's some process that is followed to ensure that individuals are receiving that written notice and to have some ability to document that that notice was in fact given or sent out. And this will again preserve your ability to raise a notice offense in the event a claimant does not file a subsequent notice of claim. And the reason why Dabata is also important is because the triggering event that requires a municipality to provide this notice to a potential claimant goes beyond the individual, the injured party, calling up and requesting it. And in fact, in Dabata, the plaintiffs did fail to provide notice. That wasn't in dispute. They didn't provide any notice. However, one of the contacting agencies was notified of an event in writing by the individual. So the individual notifies the governmental entity A, and then what happens is that governmental A turns around, compiles a list of some of its residents, and with the names and addresses of potentially injured persons, and then turns around and sends that information to the county on a list that was sent from the city to the county. Now, it wasn't the person, the individual who sent it directly to the county, but in that case it didn't matter. All the case said is that now the county received notice that these were individuals who were potentially aggrieved. They had notice of these individuals. That was enough to trigger the duty. Even though the individuals themselves didn't write the notice directly to the county, didn't matter. It was sufficient that the city provided a list that it got from the individuals, transferred it to the county. That was enough to trigger the duty to send out the requisite information to these individuals. Since the county did not do that, they lost the ability to raise a notice defense. I cannot stress enough that this is a very important, this case provides a very important lesson for municipalities. The lesson is this: if you receive notice from any individual or entity or governmental entity regarding any individual who suffered or was affected by a flood, the duty is triggered to send that individual information outlining for them when and how to file a notice of claim to satisfy MCL 691.1419. Okay, the next case I want to discuss is a 2012 case, unpublished case, entitled Slicer versus the City of St. John's. In that case, the Court of Appeals affirmed the dismissal of a lawsuit when a claimant did not properly submit a timely claim form within the 45-day notice period. In that case, unlike the Tabata case, the claimant did not provide any notice or did not provide any claim that he or she put on notice the City of St. John's of a potential claim to trigger any duty. So there being no exception being pled by the claimant means that they should have strictly followed the 45-day notice provision, which they did not. Therefore, the Court of Appeals affirmed the dismissal of the action based on governmental immunity. The last case that I think is important to consider is a case called McCahan versus Brennan. This is a Michigan Supreme Court case that was issued in 2012. And in that case, it makes it clear that strict compliance with the notice requirement for governmental immunity exceptions, in particular exceptions that you're trying to avoid governmental immunity that are statutorily mandated, these must be strictly complied with. The notice provision must be strictly complied with. And unless there's a statutory exception to the exception, you got to comply with it. There is no ability for our judiciary to create new exceptions when the clear intent of the rule is to provide strict notice. And so there is no ability for a court to create some savings provision or to look at somehow the defendant, although notice wasn't properly given, the defendant wasn't technically prejudiced. The courts can't look at that unless there's a statutory exception to the exception. The individual must comply with the notice requirement, and no court can create some new exception. So this court stands to the proposition that it is a very, very strict rule, and it's got to be complied with. And although it produces harsh results, it was the intent of the legislature to do so. Remember, we're dealing with governmental immunity and the exception there too. These exceptions are very narrowly construed. The public policy is to protect our municipalities from tort liability. So they have an ability to create these rules, and it may produce harsh results, but that's the law. So again, there is no judicially created exceptions to the notice requirements. Those exceptions that exist must exist by way of statute. Okay, so now we're at the stage that we assume now that notice was properly and timely submitted by a claimant. So the question is what happens next? What happens after that claim, that notice of claim was submitted? Well, there's still that 45-day time frame. During that time frame, a claimant cannot file a lawsuit. It's sort of like a grace period. It's a period of time in which the government has an ability to go out and investigate the claim, to determine the compensability of the claim, to determine what was the cause of the damage, to see whether or not the governmental entity and the claimant or resident can try to work things out in advance of litigation. It's to provide that efficiency that we saw earlier to this claims process. So during that 45-day period, the claimant puts the governmental entity on notice, and then the governmental entity is supposed to do some research, some investigation to see if they can avoid litigation going forward. If they can't, if the governmental entity makes a determination that it was not at fault, there is no defect in their system, they don't want to pay on the claim, then after that 45-day expiration or that 45-day time period expires, a claimant may then pursue litigation against that governmental entity, and it appears that the statute of limitations would be properly 3 years from the date of the incident. And we take this from MCL 600.5805 paren 10 n paren, where it states the period of limitations is 3 years after the time of death or injury for all other actions to recover damages for death or injury to person or property. So limitations period, this catch-all 3 years, I believe would apply here, although I haven't seen any cases on point. It's not in the statute itself. It seems that this would be the logical statute of limitations period to bring a claim. Now, I got to tell you, most of the claims I've dealt with on these sewer litigation claims generally happen to be filed very close in time after the expiration of the 45-day period. So I haven't seen any challenges to the statute of limitations, to the 3-year statute of limitations. I've only seen those challenges from a statutory notice provision, that being the only limitation period being challenged, but not to the statute of limitations, that 3-year statute. But again, the logical limitations period would be that catch-all for injury to person or property, which is being sought after here. Okay, at this point, I want to talk about some other defenses. We talked about the notice defense as being a strong defense, and I want to talk about some other defenses that one should consider after a case is filed, and then after that, we'll get into some of the available damages that could be pursued on a valid claim. So let's just first talk about those other defenses. Okay, so a case comes in and a governmental entity is being sued, and as I stated earlier, the first thing that I would do would be to look at whether or not the individual properly filed a notice of claim. Because if they didn't, I would absolutely file out of the gates a motion for summary disposition. If we don't have one on file, that's that would be the first thing I would do. You may want to do a request for admission or an interrogatory on this issue, and if you can get the right answer, then file it right away. Sometimes it may take a little more than that, depending on what the claimant says or what the claimant pleads. So that would be the first thing I would look at. I would also look at whether or not the individual properly pled avoidance of governmental immunity in their complaint. Again, because governmental immunity is the general rule where a tort action like these is being filed, they have to plead that there's an exception available that allows them to kind of avoid this governmental immunity to bring a suit. So those are the first couple of things I'd look to. Obviously, I just touched upon briefly the statute of limitations defense. Obviously, that's another thing that you want to look at, especially if the flood happened more than 3 years prior to the filing of the complaint. The reason I say that is because, generally speaking, most people know that they've been damaged and the damage occurs at the time of the flood. So if the flood event that they claim is more than 3 years beyond the filing date, then you may have a very good statute of limitations defense. The next thing I would do is to determine whether or not the area of the lines that are at issue are actually ones that are actually owned and operated by the municipality. If they're not, then they may not be a proper entity, the proper governmental agency to be sued. So that's another thing that I would look at right off the bat, because these are things that should be defined in the complaint and are pretty readily ascertainable. It may help you get to a resolution of the case, or get to people defend the case and seek a dismissal sooner, rather than going through all the discovery that could be somewhat costly. Next, we haven't talked about this yet, but it makes sense to talk about it now. What we just talked about was whether or not the municipality is a proper governmental entity. If the complaint, or if at some point in time the notice of claim provides you with some information, some level of information, which makes it clear that you are not the owner of the system as a municipality defendant, but some other municipality or governmental agency is, then under the notice provisions, this will be MCL 691.1419 subsection 4. If you look at that subsection, it does call for a governmental agency to contact another governmental agency within 15 days to let them know that they may be responsible for the injury. I think the reason for this provision was to allow that contacting agency to provide the names of potential injured parties, so that the new governmental agency who may be responsible has the duty to then turn over notice of claims and information to those individuals, so that they can timely make a claim under the rule. So it's also helpful, because even if you are sued later on and you believe some other entity is responsible, then you can examine that other entity as soon as possible to help the defense of your case. So that's one thing to consider, is not just are you the responsible party, but who would be the responsible party. So you can start kind of looking at those issues even well before you're sued. And actually, I would encourage, because a lot of these cases do end up in litigation, I would encourage as soon as possible, after you receive these notices of claims, the municipal defendants I'm speaking to right now, as soon as you receive those claims, I think you need to coordinate with the sewer and water department. I think you need to coordinate with the city engineers. I think you have to have some ability to get together to understand what the claim is, understand what the issues are, potential issues are in your system, to evaluate the damage, to evaluate your system, to determine whether or not something went wrong, or whether or not this was just an anomaly. This rainstorm was just too heavy, over capacity for your system, and there was no defect. These are issues I think you should be concerning yourselves with very early on in the process, immediately after the event. The person in the government entity out front on these issues are usually the best able to defend these issues if they're sued at some later date. It's also helpful to evaluate the claim that, that's why you have the 45-day period to look into these issues. So again, I would encourage the municipal defendants to get on these issues as soon as possible to understand what happened, why the flood occurred, and if there are other reasons, other non-municipal reasons for the cause. And I know many of you who are cities, especially in areas that have antiquated sewer systems that were built a long time ago, who deal with these sewer backup cases day in, day out, or on a yearly basis, are very proactive, very aggressive in determining these causes early on in the case. Doing a tremendous job. I've worked with some of you on these issues, which make obviously my life a lot easier when we get to the stage where we're actually defending the case. So keep up the good work if you're doing that, and if you're not doing it, you don't deal with these issues very often, if you have an occasion to have these types of claims in your township, city, I would encourage you to begin that investigatory process early on, because it's only going to help you down the road and evaluate the claim. Yeah, I mean, and again, you getting involved early on is going to help with a lot of those factual defenses that are listed here on this this particular slide. It's essentially areas which require us to negate, not really require, but smartly to get proof to negate the elements of plaintiff's burden to show liability, which is our knowledge of a particular defect, the existence of a defect. If something does exist, our knowledge of that, when we had knowledge, what steps we took to correct that alleged defect or problem, and you know, what was that reasonable? We should be looking at those as municipal defendants. You have to be looking at those and evaluating those issues early on, because it's going to become much easier to defend these cases, or again, evaluate the strength of the claim that a plaintiff may have, so that you can resolve these issues with a particular plaintiff before you get involved in expensive litigation and before you start hiring expensive experts. So again, I would encourage you to get with your city engineers, the appropriate departments, the people with the boots on the ground doing the work to understand what happened. A couple other defenses. You know, this is an exhaustive list, just ones that you should be considering. The other defense, which may be appropriate with the recent rains, is this act of God. You know, if you have act of God where there's just severe flooding or some other major weather event out of the ordinary that wasn't really anticipated, you know, among the designers of the system that caused the flooding, that may be a potential defense. A 100-year rainstorm, that certainly may be considered an act of God. The question as to whether or not the most recent storm, the August 11th storm, was a 100-year rain event, is still being considered. The radar data is not in yet, hasn't been evaluated. I have talked to some of my meteorologist friends in the local news stations, and they have said, yeah, it looks like a 100-year storm, but again, they have to review all the data. So that may be a potential defense, because these events don't happen that often for a reason. It's not anticipated. The systems aren't set up to handle those types of events. So unless there's some other defect that exacerbated the problem, it may be a very good defense. I mean, just last week, again, we saw 14 feet of water on major thoroughfares that stood there for a couple of days. So this is something I've never seen in my lifetime. I'm 36 years old now. I haven't seen it. I talked to my father and my uncles and my aunts. They've never seen the type of rainstorm that occurred. So this could be a good act of God defense when you have a very significant rain event that, again, you can't account for everything. So that's a good potential defense. The question, again, is going to be, well, it comes down to the experts, right? It's going to be, what does the expert say? Does the expert say it's a 100-year rain event? Does the expert say it's going to be something that could be that could have been anticipated, that should have been anticipated by the system, or is there some other defect that caused the issue? It's going to come down to what the experts say. And again, when you have battle of the experts in factual disputes, it makes it more difficult to win these types of cases on motion. However, it's not insurmountable. You can do it. We can do it. But again, the quicker you get to understanding the problem and being able to defend the case, the better chance you will have at winning the case on motion potentially. So let's get on to the next issue. I know we talked about defenses first. before damages, but I want to talk about damages last because, again, you can try to negate the damages as another possible defense, but there are two essential or two veins, I want to say, veins of possible damages that a aggrieved party can seek in these types of cases. The allowable damages are, again, defined by statute, MCL 691.1418, entitled Economic Damages, Grounds for Non-Economic Damages, and Available Defenses. And I'm just going to go ahead and read this, and except as provided in subsection 2, economic damages are the only compensation for a claim under section 17. Except as provided in subsection 2, a court shall not award and a governmental agency shall not pay non-economic damages as compensation for an event. So as a general rule, the only types of damages one could recover on a properly pled claim is economic damages, damages to property, damages that do not consider the mental anguish of one person, the emotional distress. Those types of injuries are considered non-economic damages. A governmental agency may have to pay out non-economic damages, but only in very rare situations. And subsection 2 tells us when that is. So under subsection 2, a governmental agency remains subject to tort liability for non-economic damages caused by an event only if the claimant or individual on whose behalf the claim is being made has suffered a death, serious impairment of a bodily function, or permanent disfigurement. And the legislature chose to define serious impairment of a bodily function similar to that term as it's defined in section 3135 of the Insurance Code. So it's the exact same definition there. It's a very high threshold that one has to meet to obtain non-economic damages. So if you cannot prove that threshold requirement stated in subsection 2, the only potential remedy you could have would be those found in economic damages only. Now that we know what types of damages are available to a properly pled claim and to a claimant who has been injured from a sewage disposal event, I want to discuss a little bit about proving those types of claims. First, let's talk about damage to personal property. Damage to property. In order to prove damage to personal property, the individual must supply reasonable proof of ownership and the value of the damaged personal property. Reasonable proof may also include testimony or records documenting ownership, purchase price, value of property, or photographic or similar evidence showing the value of property. Again, this is defined by statute MCL 691.1417, paren 4 and paren small a and paren. So again, in order to even prove to be able to obtain economic damages, the burden is still on the plaintiff to demonstrate the ownership and value and the damage through reasonable proof. Earlier on, I had my insurance friends write down two words. The first one was notice, the second one was document. And here, I want you to pay particular attention to this statute and the subsection relative to proving personal property damage. Reason being is that if you are going to be paying on a subrogation, or I'm sorry, on a first-party insurance claim, and you plan to file a subrogation claim it is crucial that you obtain the documentation necessary to substantiate the personal property that was damaged in the subject flood. So I would require that, or you should require that your insured supply you with all of the documentation that they have, photographs, pictures of the damage, receipts of purchase, video, anything that could help you prove your subrogation claim. Remember that the easiest way to get that information would be up front before you even pay out on the insurance claim. And I'm sure that all of you who deal in first-party claims require that anyways as a part of that claims process. So you should have it easily at your disposal. But I just pay particular attention to gathering that information before you pay out the claim as early as possible to make sure that your ducks are in a row when you go ahead to file, when you decide to file that subrogation claim. As far as damage to person and non-economic damages, while there is no statutory scheme, while in the statutory scheme it does not really tell us what proofs are required to demonstrate non-economic damages, seeing as though the threshold is that you first must prove that there has been either a death or a serious impairment of bodily function or permanent disfigurement, it seems logical that there would be a requirement that there would be medical testimony provided by a medical treater or other expert that could give the opinions to satisfy the elements in order for a claimant to claim non-economic damages. So that's my belief. There's not really any, well, there's no cases I've seen on this issue, but again, logic tells us that that would probably be required given the foundation needed to give an opinion concerning those issues would require a treater and or expert to give those types of opinions. One thing I didn't talk about is other than personal property, what other economic damages may be available. And as in most of the floods that I've seen that enter the home, that water goes into the basement, and it may sit there for a substantial period of time. One of the claims could be that flood water had caused some physical or structural damage to the home, and so a claimant may claim that home, the real property has been damaged. In addition to that, the flood waters may have taken out shrubs or something on the land or fixed to the land that would constitute real property damage. And again, with respect to that, there is no prohibition against claiming real property damage, so it seems fair game to be claimed in these types of cases. And it seems also that an individual could provide his or her testimony concerning the home and the damage to the home. In addition to that, I'm certain that expert appraisers concerning the diminution value type claims where they're claiming that the home decreased in value, that they'll need the requisite expert testimony from appraisers, from construction foundation experts to discuss damage to the real property. Although there are some cases that suggest that even a homeowner can familiarize oneself with the home values and determine whether or not there's been a diminution in property value. So that's another type of claim that's regularly made in these types of cases. It's the personal property damage, damage to real property, diminution in real property damage. Those are the general categories of claims being made. You don't see too many non-economic damage claims, and that's just simply because the threshold is just too high in these types of cases to make those claims. Well, we're at the point where I have now concluded what I was going to talk about in this webinar. I do appreciate your time, patience, working through this area in the law. It's very precise. It's very interesting, and it's somewhat new. So as we proceed on into the future, and as these floods become more prevalent in our communities, we may see more cases. We may see more case law being developed and outlined, and new theories being tested in these areas. There are many other issues that involve sewer backup cases, flood cases, that I'm sure you may have tons of questions on and may like more information on. And I will make myself available anytime that I can to discuss those issues that may be particular in your case, or you may have seen a situation that you're interested in outlining a strategy, or just questions to better familiarize yourself with these types of claims. Be more than happy to discuss those with you. The information, my contact information, is set forth on this last slide. And like I said, you can email me, call me anytime. Generally speaking, I will get back with you within a 24-hour period, and I look forward to speaking with any of you who have questions on this. And before I go, one of the issues I was going to get into, but we just you just don't have the time. You can actually take up an entire entire seminar or webinar is the issue of class actions. And let me just touch briefly upon that now. Many times when you have a major flood event, you're not dealing with one case. You're not dealing with two cases. You're dealing with hundreds of cases potentially, depending on the size of your community or the area that was hit with the flood. And what happens is that you'll have plaintiffs' lawyers who go into these communities and sign up many of these parties who believe they have been injured, and they'll get information from those individuals as far as the type of loss, the type of water that entered into their home, the type of damages. And what they'll do is they'll file these cases with class action allegations. So they'll file an action with a couple of individuals as representatives, and then they seek to have class certification so that they can defend these, or I'm sorry, prosecute these cases on a class-wide basis. It's advantageous for a plaintiff's lawyer to do this because, of course, there is a lot less discovery to do what needed to be done in one case than it would be to prosecute 300-400 cases individually. A lot cheaper that way, and they could still potentially gain that big attorney fee potentially in one case. So, while class action cases, we can have a whole seminar on how to defend them. I'm just going to go over it just briefly. I wasn't going to, but I do think it's important because it seems that every case I get in nowadays has class allegations. So let me just briefly discuss a couple of key points I think you should be aware of when you receive a case in with class allegations, and that is this. Again, you have to make sure that who gave the notice and whether or not there are people in the community that would be within the class that didn't give the notice. You have to look at issues that differentiate class member to class member, okay, or potential putative class member to class member. The reason I'm saying this is because generally in class actions, they're meant to provide an easy mechanism to prosecute one huge claim with a bunch of individuals who have the same basic claim. It's typical. It's a common facts. It's a common claim. It's a typical claim. It's a better method, a superior method, and it's the representation of the person is adequate. There's enough parties there. So there are various class action requirements set forth in MCR 3.501. Again, I'll just review them. Numerosity, commonality, typicality, superiority, and adequacy of representation. And where I would focus defending those cases on is the commonality and the typicality and the superiority elements. And the more you can differentiate the claims, the more you can make the claims more disparate, the less likely a court will be to certify the class. And here's the reason why. If a class has a bunch of different claims, that means that you would have to look at a bunch of individualized proofs. For example, the damages in all of these claims are going to be very individual. Not everyone has the same stuff that was injured. Not everyone has the same foundation, the same home, the same size home, the same personal property, the same injury, the same economic loss, the same non-economic loss. They're so different that you could not paint a broad brush with a class representation. These cases, if certified, would really, it would end up in mini trials, which is exactly what class action mechanism was not meant for. If it's going to result in a bunch of mini trials, a court will not certify the case to class action. They're better off being pursued on an individual basis. And here's the deal. If you get a class action and you're able to get testimony from the plaintiffs early on that demonstrate that the claims are different, you can test the class action allegations. You can file a motion to strike the class action allegations. Test those allegations, because a claim with one party in it is a whole lot different than a claim with several hundred parties in it. And it may discourage a plaintiff from bringing that class action, and you may be able to either settle the case or work toward a dismissal of the case a lot easier if you can get rid of those class action allegations. Again, because of time, I know everyone has other jobs, and while I will consider myself interesting, I probably am not all that interesting, and I know you guys probably have better things to do. So if you are as boring as me and want to get into this class action issue a little more, again, I encourage you, just give me a call. I'm more than happy to go over it. I've written several motions on this issue in the context of these types of cases and other cases, and I'd be more than happy to impart my knowledge on you to help you understand class actions and as well as sewer disposal event cases. Okay, so again, I appreciate your time, and I look forward to talking with you in the future. Thanks.